Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle, and this is our Saturday morning broadcast. It is Saturday, December 2nd, 2023. This is our weekly review, our analysis, and our discussion of those most important news events, those stories, those occurrences, those happenings in the areas of law and government and the aspiration for justice in America. Thank you so much for joining me this hour and hopefully next hour as well as we examine all of that and more. As always, we have an ambitious but very much achievable agenda, a syllabus for you this morning. I am joined in the studios here of Civic Media in downtown Waukesha by my wonderful producer this morning. His name is Greg, and together we're also taking your phone calls throughout this hour and next hour as well. That phone number, as you know, is 844-967-2789. Also on the Civic Media website, go on the app, find Civic Media, pull down your particular broadcast station, find Morning Cannolis, and send us a note. Greg and I are loving to take your comments, your questions, especially your inquiries about things that we're talking about this morning. As always, here on our Saturday morning broadcast, delighted and honored that you have set aside some time on this Saturday morning, the first Saturday in December, to spend some time in discussion, in consumption with us of these major news stories that affect our lives and our livelihoods here in the state of Wisconsin and throughout the United States of America. I mentioned that, as always, our agenda is a big one, chock full of a lot of things happening, lots of things to cover from just this past week and beyond. And we always ask, in connection with our ambitious but achievable agenda, three major questions. What are those questions? Those questions are these. First, what happened? What do we know? What are the facts of the events, the circumstances that are animating our discussions these mornings? Second, why are those things important? Why should we care? Why are they significant? Why are they meaningful and material to our lives today, in the past, and also in the future? And finally, in many instances, what should we do about those things? How should we react? How might we react? What are our options across the political aisles? What kinds of things should we think about in terms of reactions and answers to those major issues, those events, those circumstances that are animating our lives every single week? I mentioned once again that we do have a lot to cover this morning, and I'm going to tell you a little bit about our syllabus this morning and then go back and spend some major time in the first segments of this first hour talking about yet another icon who we lost just this past week. Her name, of course, Sandra Day O'Connor, an Associate Justice of the Supreme Court for nearly 25 years, a quarter century. We do some reminiscing about who she was and specifically talk about not only her legacy, focusing on two particular cases and the importance of those cases to this day, and then also focusing beyond that upon the personal side, the individual side, the human side of Sandra Day O'Connor. Some stories we're going to talk about engaging with Thurgood Marshall and, yes, also other members of the Supreme Court when she was on that high court during the course of her 25 years. That includes her great friend, Ruth Bader Ginsburg. We're going to get to that memorial, that discussion in just a few moments. But as always, we also have a lot of news to focus on, lots of things to comment about, and to solicit your questions on throughout our broadcast this morning. Those kinds of things include these. Some major decisions just this past week, including just yesterday, in connection with the continuing litigation involving our former president and present candidate for the presidency of the United States of America. His name, of course, is Donald Trump. Three major appeals court and district court decisions coming out just in the past several days that have a dramatic impact upon the circumstances, the ways in which those cases will be litigated in the weeks, the months, and yes, indeed, the years ahead here in our federal and our state courts. Going ahead in the coming weeks and years. Those cases, the subjects of our discussion right after we talk about Sandra Day O'Connor this morning. Then we're going to talk about two other major events, as we sometimes do. We're going to take a look at one of the convictions, the sentences imposed upon one of the January 6th insurrection rioters. We're going to chat about the significance of that, as we sometimes do, the deterrent effect that it should have upon all Americans when they should think about possibly engaging in that kind of violent behavior once again. This particular defendant, notorious and famous in our recent history, our sports history in America, we'll talk about the things that he said following his sentencing just this past week in the federal district court in the District of Columbia. And then we're also going to turn to another instance of violence that has made its way into our federal court by virtue of an indictment returned by a federal grand jury, an indictment that alleges an attempt to commit homicide, murder, an attempt unsuccessfully, thank you, and thankfully here in the United States of America, against a Sikh separatist living here, advocating for the separation of a particular Sikh state, the province of Punjab in India, advocating for that pursuant to the First Amendment here in the United States of America, a plot that was discovered by our federal law enforcement authorities and thwarted and stopped here, that has reminiscence of and mirrors of a similar type event that happened in Canada. We'll talk about all of that, the connection between India and attempts, at least one attempt, perhaps one other successful attempt in Canada, to go after people who are advocating for Sikh separatism in the state of India, the country of India, the largest republic on the face of our planet, the most populous, almost most populous nation on our planet. And then we're going to spend a lot of time principally in our second hour this morning, talking a huge amount about the Supreme Court once again, not only in memory of Ruth Bader Ginsburg, but also talking about the significant things that will be happening in the coming week. The Supreme Court going to be taking up a number of additional cases for oral argument. You can hear those, you can digest those, you can consume the things that the Supreme Court justices are quizzing the attorneys about. By going online, you can pull down those transcripts. You can listen to them live and also recorded. And we're also going to chat centrally about a major oral argument of just this past week in what I believe is one of the most significant series of cases pending right now before the United States Supreme Court, that having to do with what's called in the political arena the administrative state, our agencies, our federal agencies that make our government work, that make it go, that ensure that in all ways, important and perhaps sometimes even unimportant, our government is functioning. A focus by the Supreme Court through three different cases, one of which was argued centrally this week, having to do with the legitimacy of our federal agencies, their constitutionality. This one in particular focusing upon the future, the viability, the constitutional provisions, and the operations of, yes, that's right, the Securities and Exchange Commission, been around for 90 years, almost a complete century, now called into question by the United States Supreme Court, whether or not one who appears before the SEC, someone who has been the subject of an investigation, and yes, the imposition of penalties by virtue of findings by the SEC, whether you have a right to a jury trial before the SEC, that's also before the Supreme Court just this past week. We're going to talk about what the Supreme Court justices said in response and read some of the tea leaves about what the Supreme Court may do when it comes to May, June, perhaps even July of next year, rendering its decision on this major case and two other cases, one of which we also previously discussed involving the Consumer Financial Protection Bureau, and a big one coming up in mid-January, a major oral argument in mid-January on a larger issue having to do with the relationship between our federal courts and the ways in which our federal agencies work, whether there should be deference, whether there should be a sense of acknowledging the expertise inside our federal agencies by our federal judiciary in areas where scientists and mathematicians and medical people and educators and engineers and all the kinds of people who make our lives go, whether there should be some understanding that their expertise is worth something and should be deferred to when, in fact, the legislation passed by the Congress is perhaps not as complete as it should be. And we defer to those agencies to give us direction and even counsel and even a sense of where we're going when it comes to interpreting the law in America. We're going to talk about all of that in our second hour this morning. All of that also inviting to you, making this invitation to you to be engaged in our conversation. That is a conversation that you can involve us in. You can be involved in. That phone number is 844-967-2789. Greg and I here in the studios of Civic Media, delighted to take your phone calls as we go ahead, and also soliciting your comments. You can even write to me and write to Greg. Tell us what you think. Articulate your question in writing, and we'll pull that up as well and respond to that throughout our broadcast this morning. Delighted to have you with us remotely. Delighted to have you being a part of our conversation about law and government and the aspiration for justice in America. All of that hugely important. I indicated that as a part of our aggressive but achievable agenda this morning that we necessarily need to, it is appropriate to, should talk about Sandra Day O'Connor. Sandra Day O'Connor, 1930, born in 1930, left us, departed us this past week, 2023. A remarkable life. Last week we talked about former First Lady Rosalynn Carter. In many ways, Sandra Day O'Connor also, like Rosalynn Carter, an icon in American history, changed America to the good, to the profoundly good, when it comes to understanding not just the role that women should in fact play in all aspects of our lives, but the critically important things that people like Sandra Day O'Connor and yes, Rosalynn Carter bring to the deliberation about major issues in our nation, the significance of their contributions, the leadership, the insight, the direction that they give to all of us who are interested in ensuring that our America proceeds in a land of justice and peace. Sandra Day O'Connor embodying all of that as well. This icon, 25 years on the federal bench in Washington, D.C., changing the ways in which we think about the judiciary. We're going to talk not only about her legacy right after this first break, but also talking about a couple of additional cases that regrettably have been overturned, that she had not only her fingerprints all over, but she authored, and the consequences of the overturning of those cases in recent times. Stay with us for that important discussion right after this first break. We are back here on our Saturday morning broadcast. Thank you once again for joining me and my wonderful producer, Greg, here in the studios of Civic Media, taking your phone calls this morning, as always, at 844-967-2789. You could also go on the Civic Media app, find us, send us your questions, specifically your inquiries about things that we are chatting about this morning. We're going to spend much of this segment of our Saturday morning show talking about Sandra Day O'Connor, the first woman on the United States Supreme Court appointed by former President Ronald Reagan, taking the office in 1981. An awful lot of focus these days upon the significance of that. And yes, indeed, it was a significant event in American history, in human history, that in our nation, in 1981, the first woman, long overdue, takes her proper seat on the United States Supreme Court. About 120 justices of our Supreme Court throughout our history, and to this day, only six of them, have been women. Sandra Day O'Connor led that movement of ensuring that there is more representation. Still not enough historically and presently on our Supreme Court, but we're moving in that right direction, and she initiated that. She initiated when Ronald Reagan tapped her from an Arizona appeals court where she had been practicing first as a lawyer. She was also a legislator there, and then on the bench there. And then on the bench, establishing a reputation, even then back in Arizona, as someone of intelligence and thought and focus on justice, the kinds of things that we discuss here on this radio program always. Let's talk more about who she was, the kinds of things that she brought to the High Court during the 25 years, the quarter century that she was there on our court. It's fair to say that very little could have happened without Justice Sandra Day O'Connor's support, her encouragement when it came to the very polarizing issues, even then, 1980s, 1990s, the first years of this century as well, on very important issues involving all sorts of things. Affirmative action, which we'll get back to in just a moment. Abortion, also a major voice in that area as well. Voting rights, religion, federalism, the role between the federal government and state governments. Other things involving sex discrimination, immutable characteristics, all kinds of things, interpreting our federal laws on her docket during those times. Many other hot-button subjects of that time that remain a part of our discussion to this day. Sandra Day O'Connor at the core of much of that because of the middle ground that she staked out, and a middle ground that was acknowledged in what was, even at that time, a polarized and polarizing America, and a court that sometimes reflected that as well. That middle ground that she always looked for resulted in a justice that was promoting and identifying in her opinions, in the questions that she asked from the bench, a justice who was interested in ensuring, again, justice, the promotion of the rule of law. Along the way, it was no coincidence that, given the fact that she was very much aware of her place in history, not only as the first woman, but also as this person who understood the role of a Supreme Court justice, that on a regular basis, she looked to current events. And even, yes, that's right, the public mood in getting a sense of where the nation was and understanding not necessarily that the Supreme Court should reflect completely what polls or what the public says the Supreme Court should do, but nonetheless understanding that the Supreme Court lives in contemporary times. She would be the kind of person who today would tell you that even our Constitution needs to be a living Constitution, one that reflects where America is, ever-changing, ever-evolving. We would like to think in America forever moving toward a place of greater understanding, greater due process, greater equal protection, all those things promised by our founding fathers. She was a part of that. As a part of the things that she commented about later in a book that she called The Majesty of the Law, Reflections of a Supreme Court Justice, which is a collection of her essays. It was published in 2003. She could have staked out that middle ground, and she said this. She said, rare indeed is the legal victory in court or legislature that is not a careful byproduct of an emerging social consensus. An emerging social consensus. That's the Sandra Day O'Connor that we remember so very, very well. We know as well that during the course of her term, she was the principal author again and the principal architect of many major cases. And along the way, again, scoping out this ground that was identified by many as being an incrementalist, that is, moving in support of where America is, where it should be, incrementally to ensure that the law not only adopts and reflects where we are as a nation, but sometimes also leads in those areas too. She's called this incrementalist because she was not a believer, as we have seen in some of the Supreme Court decisions of recent times, in major reversals, 40-year, 50-year reversals of tradition and scope in America. She believed in movement that reflected the understanding of our American population as it too moved toward a greater codification and embracing of who we are as a nation. Let's talk about a couple of those cases, and regrettably, let's also talk about the rescission of some of the things that she wrote about when it comes to these two major cases. Again, many, many other things that we could spend a lot of time talking about. I encourage you to take a closer look at her entire corpus of decisions that she rendered while she was on the Supreme Court, Sandra Day O'Connor. We're going to talk about two of them. We have spoken a lot on this broadcast about a case called Roe versus Wade, 1973. Harry Blackmun, a justice on the bench long before Sandra Day O'Connor was there, writes this landmark decision finding that, yes, inside the Constitution of our United States of America is this privacy right, a privacy right first established by Griswold versus Connecticut. In this instance, in Roe versus Wade, that privacy right takes its codification. It inhabits the right to abortion. It inhabits the right to reproductive rights, and that's what the Supreme Court identifies in 1973. It establishes a framework that Sandra Day O'Connor revisits in 1992 in a case called Planned Parenthood versus Casey. Planned Parenthood versus Casey in 1992, a landmark decision of the Supreme Court, again, years after the 1973 decision in Roe versus Wade, in which the court once again reaffirmed that right to an abortion as established in what's called the essential holding of Roe versus Wade. This was authored in many ways by Sandra Day O'Connor. She was the one who articulated this view once again a couple of decades after Roe versus Wade, and established and issued as the key judgment in this case called Casey, the restoration of the undue burden standard when evaluating what are called state-imposed restrictions on that right. Where does that come from? What does that all mean? Well, it turns out that in the wake of Roe versus Wade in 1973, establishing this privacy right under our Constitution, the next attack on that privacy right was not so much an attack frontal on it, but rather on the side, collateral attack upon it, based upon the notion that access to it could be a way of limiting abortion in the states of our country. And so many attempts by others who are not in favor of the decision in Roe versus Wade to attack it again collaterally by saying, we will restrict access to the right that we know you have. And so the case in Casey arose this way. It arose from a challenge to 5 different provisions of a Pennsylvania Abortion Control Act of 1982. Among those provisions were requirements, for example, for a waiting period before you could get an abortion, special notice, other things like that, which we're going to talk about as we come back after this next break. Tell you more about Casey, tell you more about how it is that Sandra Day O'Connor responded to that in a landmark case in UK. We are back here on our Saturday morning broadcast, spending some time thinking about the legacy of Sandra Day O'Connor, hugely significant person on the Supreme Court in the history of America, whose legacy also altered by what happened after she was on the Supreme Court, including some major decisions of the very person who took her place. We're going to get to that in just a few moments or so. Right before the break, we're talking about this major case that she did, in fact, issue, the principal author of a case called Planned Parenthood versus Casey, in which there was a challenge to the Pennsylvania Abortion Control Act of 1982, requiring that certain steps be taken before you can get access to abortion in the state of Pennsylvania, including a waiting period, spousal notice, parental consent for minors, those kinds of things. And in a plurality opinion, it was Justice Sandra Day O'Connor, along with Anthony Kennedy and David Souter, that the Supreme Court upheld once again this essential holding of Roe that did in fact say that under the Due Process Clause of the 14th Amendment and generally in our Constitution, the woman's right to have an abortion prior to fetal viability is in fact established. Now, the court in Casey overturned the Roe trimester framework that had been established way back in 1973 in favor of this viability analysis, which remained the law of the land until 2022. And why it did that? Because it allowed states then to implement abortion restrictions that apply during the first trimester of pregnancy, that to ensure that the law, in fact, reflects the trimesters, but also that there's this focus upon viability. And in its key judgment, the court overturned Roe's strict scrutiny standard of review of those restrictions, and in particular established this undue burden standard. The author of that was Sandra Day O'Connor. And under that rubric, under that standard, the restrictions on the abortion right would be constitutional or unconstitutional when they were enacted for the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. That was Sandra Day O'Connor and others writing in 1992. That case, the Casey case, along, of course, with Roe versus Wade, remained the law of this land until when? Until 2022, and it is an ironic aspect of our American history that following her retirement, she was replaced on the bench by a justice named Sam Alito. Sam Alito, who remains on the bench to this day. And Sam Alito, 18 months ago, was the author, the principal author of the majority opinion that overruled both Roe versus Wade and also Casey, this wonderful, important, significant statement by Sandra Day O'Connor about privacy rights in America. Sam Alito, the very person who overturned that decision of the Supreme Court written by Sandra Day O'Connor, followed her in that very spot. In the wake of her retirement, she was asked various times by some not only law enforcement folks, people who are in journalism, focusing upon the administration of the law, but also by journalists as well. And the question was whether or not she was in any way upset or concerned by what was identified as this significant shift away from what she had articulated. And the response that came back from Sandra Day O'Connor was, what would you feel? What would you feel? And she talked about the fact that her cases, her decisions, at least in this and one other matter, which we'll also talk about now, were being dismantled. Were being dismantled by the court. And indeed, that is a part of the history in the wake of this important work by Sandra Day O'Connor. We've got a wonderful text from Jeff in Sherwood who notes just that. He writes in to Greg and me, says, she was impactful, she was reasonable, and she was justice-based. And while, yes, indeed, that's right, she did leave the court principally because she wanted to take care of her ailing husband. Jeff notes the irony once again that she was followed in that position by Sam Alito, who ended up overturning, by virtue of his pen, the very things, many traditions that she'd established on the court. Jeff, appreciate that very good commentary coming to us from Shorewood this morning as well. There's a second case I also want to talk about because it reflects upon other things we've chatted about here on our Saturday morning broadcast, and that is affirmative action. It follows in many ways. The same history that we saw when it came to Casey, and it's being overturned in the Dobbs decision in June of 2022. This case is a case called Grutter versus Bollinger. It's in 2003. Again, a landmark case of the Supreme Court way back then. Concerning what? Concerning affirmative action in student admissions. Does that sound familiar? It should. The court held that a student admissions process that favors underrepresented minority groups, the way that they described the petitioners, the plaintiffs in this case, a group that would be identified in that category did not in fact violate the Constitution, the 14th Amendment's Equal Protection Clause, so long as this process, this admission process, took into account other factors evaluated by an admissions officer, an admissions policy group, other people reviewing applications of candidates for admission. That was Grutter versus Bollinger in 2003, 20 years ago. And that decision, of course, you may recall another decision called Bakke back in 1978 that allowed race to be also considered, but held at racial quotas. You can't specifically identify a quota and affiliate that with a particular race. That was found unconstitutional in Bakke. Justice Sandra Day O'Connor built on Bakke, built upon the tradition of America in the Constitution, and Grutter versus Bollinger 20 years ago in finding that student admissions could in fact be predicated in part upon a consideration of race. And of course, we know well what happened there as well. The case coming out of the University of Michigan alleged that the particular prospective student had been denied admission because the school gave certain minority groups a significantly greater chance of admission. The school admitted at the time that its admission process did favor certain minority groups, but argued that there was a compelling state interest to ensure a critical mass of students from minority groups. And indeed, Sandra Day O'Connor picked up on just that in her opinion. She said there's something good and right and decent that comes from people sitting in the same classroom with you when they look different from than you do. They may have different experiences than the ones that you have had. And she said as long as the prohibitions of of the law generally are there. There's nothing that prohibits an admissions council from reviewing candidacies based in part upon race, and focused in particular that those admissions decisions can further a compelling interest in obtaining the educational benefits, she described them, that flow from a diverse student body. Shades of Brown versus Board of Education, also a part of our nation's history. The race-conscious admissions policies, again, in Gutter versus Bollinger, should be limited in time, interestingly, she said. She talked about the possibility that in 25 years from now, maybe the use of racial preferences will no longer be necessary. That language invoked more recently by the Supreme Court in overturning Gutter versus Bollinger, turning back the thoughtful and insightful things that Justice Sandra Day O'Connor articulated back in 2003, overturning that case 2023 in a case called Students for Fair Admissions of Harvard versus Harvard and North Carolina. That case finding that is in fact unconstitutional. These affirmative action programs violated the Due Protection Clause of the 14th Amendment. And so just like the case Planned Parenthood overturning the abortion decision in Roe versus Wade, Gutter versus Bollinger overturned recently by our United States Supreme Court. Interesting history as a part of all of this moving forward. I would offer in those areas and others that we have discussed, not a movement in the right direction. Sandra Day O'Connor was someone who's moving us as a nation in a greater embracing of the incremental movements that we should have in the country. Sometimes, yes, requiring more broad movements, bringing us, sometimes even dragging and kicking into a better land, a better understanding of who we all are. But she advanced that purpose. In recent years, our Supreme Court turning back on some of that tradition. Let's talk more about who she was and what she did along the way after her retirement, the time that she was talking and observing this dismantling of some portions, not all, but some portions of her legacy. She was a visiting judge in many appeals courts around the country. She was advocating not only for judicial independence, a big source of her concern, not only in the time on the bench, but also in the wake of her time there, but also focusing on what we focus on here on this broadcast of civic media, and that is civics, doing education, ensuring that whatever your politics are, whatever your partisan prerogatives may be, wherever you may lie on the political scale, if you will, the geography of partisan politics, if it is that in your own lives, that civics are the way to understand the world in which we live. An informed electorate, she often talked about, is one that votes wisely and that brings to the polling booth wisdom when it comes to selecting representatives. That was her focus in the many years since the time that she was on the bench. When she was on the bench, Sandra Day O'Connor consistently was the one who often jumped in at the start, very often the first to speak, asking counsel things like, is your case properly in this court? Why shouldn't we dismiss it as moot, as overcome by the facts, maybe even the law? She would ask attorneys almost immediately, what gives your case, your client, standing? Something we've chatted about a lot during the course of our discussion here on this broadcast. Justice Anthony Kennedy described her with great admiration as a pragmatist. Again, this person who understood what's going on out there in the world, but also brought that to her decisions. He defined her as paying attention to real-world consequences, something we need a lot of on every court of this land, but certainly the Supreme Court to this day. Justice Kennedy wrote in a tribute published after retirement that she was grounded in real experience. Two other reminiscences about Sandra Day O'Connor, one having to do with Justice Marshall, the other having to do with Justice Ruth Bader Ginsburg. She was, of course, on the bench when she was there with Justice Thurgood Marshall, and even following his retirement in 1991, she offered a hint that her own views on racial justice were evolving because of her involvement, her partnership, even her friendship with Thurgood Marshall. In an essay that she wrote for the Stanford Law Review, Justice O'Connor described the impact of serving with that civil rights giant for 10 years on the bench. She said when she was sitting there at the conference table, listening to him describe the experience of his life, she was animated, that changed her as a human being. And she went on to say that his stories always had a point. She said, constantly pushing and prodding us, including her, to respond not only to the persuasiveness of particular legal arguments, the things that lawyers love to talk about, but also to the power of what she described as moral truth. Moral truth. That's Sandra Day O'Connor talking about Thurgood Marshall. She added that she found herself listening to Justice Marshall's voice, hoping to hear just once more another story that would by and by perhaps change the way that I saw the world. That coming from Justice Sandra Day O'Connor. And then a final story having to do with her great friendship with the second woman who took the bench with her on the United States Supreme Court. And her name, of course, is Ruth Bader Ginsburg. For many years, Ruth Bader Ginsburg alone on the court as the only woman there. But we know that many years, about 11 years after the appointment of Ruth Bader, after Sandra Day O'Connor was there for 11 years, she's joined by Ruth Bader Ginsburg. She becomes, again, the second woman on the high court at that time. Nominated by Bill Clinton, 1993, Justice Ginsburg undeniably drew heavily on Justice O'Connor's opinion in many cases, including a major case in 1996 declaring unconstitutional an all-male admissions policy of a state-supported military college, the Virginia Military Institute, a major case in Supreme Court history. Justice O'Connor was visibly misty-eyed during the ceremony. Justice Ginsburg took the judicial office. She said this. She said, I can't tell you how happy I was when she came to the court. She said, it makes a night and day difference to have women on the bench. Indeed, it does. Indeed, it does. Sandra Day O'Connor, a lion, an icon in American history. We remember her this day. Saturday morning broadcast, spending some time in this, our first hour of our broadcast, talking all about Sandra Day O'Connor, promising some discussion also about major events in this segment, and then in our second hour, beginning at 10 a.m., shortly after 10 a.m. this morning, turning to those major events. I am in the studios here of Civic Media, along with my wonderful producer, Greg. We're taking your phone calls, as always, at 844-967-2789. Also taking your texts, your comments about our broadcast this morning, especially your questions. One final story, a humorous story about Sandra Day O'Connor, this wonderful human being. When Ruth Bader Ginsburg took the court, it was not uncommon, unbelievably, for some of the male lawyers who were arguing before the court to have difficulty telling them apart. They look nothing alike, of course, nor did they sound alike at all. But those frequent mix-ups reported by many people, journalists of the court, and even recorded to this day, those mix-up, even by highly experienced members of the court, prompted the two, at that time, female members of our Supreme Court to do this. At one point, inspired by these problems that some of the male attorneys had in distinguishing the two of this, they appeared at a reception for female judges. They were sporting complimentary T-shirts. One of them said, "I'm Ruth, not Sandra," that, of course, being worn by Ruth Bader Ginsburg. The other one, "I'm Sandra, not Ruth," being worn, of course, by Sandra Day O'Connor. And they spent the entire event wearing those T-shirts as a way of once again underscoring not only the silliness of what was going on from time to time in that very formal setting, but also affirming, I would say today, the importance of diversity on our bench, certainly gender diversity, racial diversity, all kinds of mutable characteristics, and bring again, as Ruth Bader Ginsburg did, as the other four members of the Supreme Court, who are also females to this day, also bring to that bench some diversity in perspective. We may disagree with them from time to time. That's a part of our national history. That's a part of our tradition. That is a part of why we are America. But we always look to our Supreme Court justices to provide the kind of insight and the direction and the inspiration that was a part of Ruth Bader Ginsburg and especially Sandra Day O'Connor. We remember her today as an icon in our American history. In many ways, what Ruth Bader Ginsburg was all about was the rule of law. And indeed, there were some major events just this past week coming out of the lower federal courts, not the Supreme Court. We're going to get to that in our second hour. But a number of different decisions coming out of our lower courts, including a state court in New York. We recall well that right now pending in a Manhattan state court is this civil litigation brought by the Attorney General there, Letitia James, against the Trump Organization, Donald Trump, his family members, alleging improper violative accounting when it comes to the valuation of properties. And you recall well that during the course of this litigation, Donald Trump, principally outside of the court, but not exclusively, has attacked the court, in particular, the court's clerk, suggesting in some postings that she has a relationship with a member of Congress. His name is Chuck Schumer, the majority leader in the United States Senate, that causing the presiding judge, Judge Arthur Engoron, to impose what was referred to as a gag order, again, language I'm not embracing because it suggests that there's a violation of First Amendment rights. He imposed an order telling him to knock it off. You can't be attacking court staff, especially when Donald Trump does not understand even what the court clerk is doing in terms of support of the judge. Well, that decision to tell him to stop commenting outside of court about the court staff has prompted a couple of things. One is because of Donald Trump's comments, we know now from just this past week that the court staff receiving phone calls, 20 to 30 calls a day, sometimes 30 to 50 messages daily on social media, threatening, haranguing the court staff because of what Donald Trump has said out there, prompting once again Judge Engoron, even before all that happens, to say you can't be doing that. That is violative of our basic standards for the conduct of trials. And the decision that Judge Engoron articulated, telling this defendant that he cannot continue to do that, brought up to the Court of Appeals, the State Court of Appeals in New York, and the State Court of Appeals just this past week affirming the capacity of Judge Engoron to restrict the defendant, Donald Trump, from saying these kinds of things, affirming this notion that just because you have some First Amendment rights does not mean that you've got an unfettered right. It is not an unconditioned right when you are a defendant, civilly or criminally, in this case, civilly, to say whatever you want about court staff. The Court of Appeals in New York just this past week announcing that it is affirming the lower court decision. Now, Donald Trump may take that up and seek further review of that in New York. But Judge Engoron announced that during the course of the proceedings and indicated that he is going to enforce that vigorously and aggressively in the coming days. We'll see what he does if indeed Donald Trump fails in that forum to follow the directives now of an appeals court in the state of New York, telling him that he cannot, and under the Constitution, he does not have the right to engage in this kind of violative language. A couple of other things also coming out of federal courts, these both in the District of Columbia, also in the tradition of the rule of law and justice that animates us to this day, from the tradition of Sandra Day O'Connor and others. First, in the federal criminal case pending before Judge Tanya Chutkan. Tanya Chutkan, again, she is presiding over this federal criminal case brought by special counsel Jack Smith. This 4-count indictment alleging a singular defendant, Donald Trump, having violated federal law when it comes to election interference. This is a big one. It's going to trial, presumably in March of this coming year. Along the way, just this past week, a petition by the defense pending for a while, challenging whether or not Donald Trump would have an absolute claim of immunity because of his status as the former president of the United States of America. Tanya Chutkan just this past week saying clearly, dispositively, he is not immune from this prosecution for his election interference, and nothing about the present status of his candidacy undermines that. Tanya Chutkan amounts to a sharp rejection of the challenges that the Trump defense team has articulated up to this time in support of the dismissal of this case. That's not happening. When we come back after this top of the hour break, I'll tell you more about what Tanya Chutkan said in dismissing this notion that somehow he is immune from this criminal prosecution. And then we'll talk about a civil case in which an appeals court, also in the District of Columbia, adopted that same concept, likewise to permit a civil case to go forward. Stay with us for that further discussion here on our Saturday morning broadcast.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle. This is our Saturday morning broadcast. Thank you for joining me and my wonderful producer, Greg, here in the studios of the civic media outlets throughout the state of Wisconsin. Thank you for spending some time with us in this, our second hour of the broadcast, talking as we always do about the aspiration for justice in America, law, government, issues, and animating our lives, our livelihoods, and speaking this morning about some updates coming out of our federal courts, our state courts as well, having to do with the major pieces of litigation pending in those courts. Right before the top of the hour break, talking about a major decision issued by Judge Tanya Chutkan. She is a federal district court judge in the District of Columbia. She is presiding over what will be a trial in March of next year. That's when she has scheduled the trial of this very, very important major indictment charging Donald Trump with 4 different counts of election interference, that being prosecuted by the U.S. Department of Justice and Jack Smith, who, of course, is the special counsel there. She has before her this request by the defense to dismiss the case based upon the notion, the doctrine, the argument that Donald Trump, by virtue of his status as the president, was immune from any sort of criminal prosecution like this. Judge Tanya Chutkan just this past week recognizing that she is obliged to respond in these pretrial periods to those kinds of motions, basically saying these arguments are not valid at all, rejecting those, saying that indeed he is not immune from criminal prosecution. Along the way, saying some very important things about the rule of law generally when it comes to any president, any person in the federal district court. In a ruling, Judge Chutkan said that the office of the presidency does not confer a lifelong, as she described it, get out of jail free pass. That's what she writes in her omnibus order, dismissing this notion that there is immunity that attaches to the former president. She said former presidents enjoy no special conditions on their federal criminal liability. This defendant may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. And she's probably referencing there the notion that, again, there is this internal memorandum inside the Department of Justice that says when there is a sitting president, that person, whoever that person may be, not subject as a policy matter, not a legislative matter, not a judicial finding, that indeed there should be some consideration for the presidency during the time in office. But she's saying that this defendant can, in fact, be subject to criminal prosecution for the things that he did when he's out of office now. That's Tanya Chutkan's great statement about the rule of law just this past week. She also rejected Trump's claims that this indictment somehow violates his rights under the Constitution generally, his free speech rights, his First Amendment rights, obviously especially important at a time when he is out there campaigning for the presidency. We know that with respect to that matter, the case that is the challenge to her imposition of a so-called gag order, restrictive order, that's pending before the D.C. Court of Appeals, just like the case involving the New York judge, Judge Engoron, actually referred to as Justice Engoron. He presides in the Superior Court there. That's the way they describe them in New York. That particular case has its parallel in the federal system. Judge Chutkan's similar order directing that this defendant not, in fact, engage in the kinds of incendiary statements that he has made in the past. That's also pending right now before the Court of Appeals in the District of Columbia, the federal court. And it sounded from the oral argument of a couple of weeks ago that the Court of Appeals is probably going to affirm that lower court order, but also saying along the way that there may be some accommodations that can be made under the First Amendment that do not implicate and do not affect the conduct of the trial before Judge Chutkan. The court in Judge Chutkan's ruling on the immunity issue, this major petition for dismissal, also said it is well established that the First Amendment does not protect speech that is used as an instrument of crime. That's what she said just this past week. The defendant is not being prosecuted simply for making false statements, but rather for knowingly making false statements in furtherance of a criminal conspiracy and obstructing the electoral process. That's what Judge Chutkan wrote in dismissing this notion that the case should be dismissed based upon immunity principles. All of this happening at the same time that the D.C. Court of Appeals, same venue, different court, higher court, addressed also in an order just issued yesterday a somewhat similar situation, a somewhat similar set of doctrines about whether or not there is immunity, this one having to do with some civil lawsuits. Some civil lawsuits have been brought by House Democrats in the House of Representatives, and some officers who were involved in trying to protect our Capitol on January 6th. And in particular, they allege that they were injured in that riot. They have brought a civil lawsuit in federal court, as have others in the federal court, alleging that Donald Trump is responsible for the injuries that they suffered, both as members of Congress and these particular officers as well, and that his conduct is directly attributable to the kinds of injuries that they suffered, that he should be held, according to the complaint, the civil complaint in those cases, accountable for his conduct in inciting the riot that caused this disruption. More than 2 years later, these cases continue to percolate up and around. And as a result of that, the appeals court addressing whether or not those civil cases should be permitted to go ahead, be tried in a district court. The district court in District of Columbia just yesterday issued a major order. This, again, the U.S. Court of Appeals in the District of Columbia, basically knocking down Donald Trump's very sweeping claims that presidential immunity, again, the same concept in this civil environment, somehow shields him from liability in these civil lawsuits brought by the lawmakers, the legislators, the Democrats in Congress, and also these police officers. The three-judge panel that made this decision, again, permitting the lawsuit to go ahead, also said that he can continue to fight in this trial. He can continue to present evidence, doesn't shut him down entirely, but just that the notion of immunity, at least at this stage in the proceedings, is not a bar to the case going ahead. Trump had said that he can't be sued over his role, whatever that may have been in the riot, because of these are matters of public concern, that, again, he is immune from this kind of prosecution, and that he has absolute presidential immunity. The Court of Appeals, like Judge Tanya Chutkan, the lower court in the criminal case, just yesterday finding just the opposite, rejecting what Donald Trump and his lawyers have said. and telling him that indeed the case will go ahead. The principal judge of the three-judge panel wrote this. He said, he is acting as an office seeker, not an office holder. No less than are the persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. In other words, he is serving in a campaign role there, not doing anything in the scope of his actual duties and responsibilities. And for that reason, immunity does not attach. So major cases coming out of state and federal district and appeals courts just in recent days affecting the future of those prosecutions and permitting them to go ahead and affirming them, at least as to the federal case in front of Judge Chutkan, this fundamental notion, and also the civil case, that the immunity doctrine that does apply in some instances does not apply here when the defendant is not acting in the scope of his official duties and responsibilities, but serving simply as a campaign advocate for his own candidacy for the presidency. An important concept. No one is above the law. That's what the courts are saying. We always appreciate your calls, your comments, and indeed, we've got a caller this morning, Dana from La Crosse. Appreciate your calling in this morning to be a part of our discussion. Thanks for joining us.
Hi, good morning, Jim. Thanks for taking my call. It's been a while.
Glad to have you with us, Dana, right?
You betcha. Rest assured, I'm still listening every weekend.
Wonderful.
It's just a great show. I think the time slot you have here, this is definitely the best thing available on any airwaves, and I hope you're getting more and more listeners to discover you every weekend.
Well, I appreciate that very much. Spread the word. We always appreciate also your calling in and with comments and questions.
You betcha. I'd like to visit the gag order issue. So we all know what he's up to with all his tweets and his attacks on basically anybody involved with any of these trials, and then down to their wives and everything. It's just incredible. And then whining about, and he's got his surrogates doing the same about how he's being persecuted, not being allowed to discuss the trials and everything, to defend himself publicly. When we all know, those of us that aren't enamored with his dazzling personality, we all know that he's been given more leeway than anybody in this country would ever be given, and definitely a two-tiered system there, but not in the way they want to define it. What I am wondering, Jim, is a possible scenario that I think could happen. And let's say the trial doesn't end up the way we are all hoping and thinking it definitely should. And it is found that he did have an effect on witnesses or other people involved with the court, and it did alter the outcome. So in most cases, in the justice system, people can appeal. Can the people appeal or sue and ask for a do-over?
Right.
Or any implications?
Sure. What is the remedy? Right. What is, regardless of what the result is, right?
Remedy?
And Dana, I'm going to have you stay on the line because I'm going to take a break right now, and then I'm going to come back and address your question right after this break. A great thought, a great question this morning. What happens?
Jim, I'll take you off the air.
Wonderful. Dana, thanks for calling in. We'll take that up right after this break.
When it's cold outside, I've got the month of May. I guess you said what can make me feel this way, my girl. Listen, baby, ain't no mountain high, ain't no valley low.
We are back here on our Saturday morning broadcast. Thank you for joining me and my terrific producer, Greg, this morning here on Civic Media, the stations throughout the state of Wisconsin. We're talking about many things this morning, including the Supreme Court. We're going to get back to that in our final segments of this hour. Right before the break, taking this wonderful question from Dana, who's calling in from La Crosse, asking about the consequences of someone, any defendant out there, who would undermine the systems of justice by having an impact, for example, upon the witnesses, having an impact upon members of the jury, having an impact upon the actual result in the trial. What if it goes in a direction, either conviction or non-conviction? What if there is some strong sense that indeed the statements made did in fact implicate issues related to the legitimacy of the proceedings themselves, prompted witnesses not to testify as they otherwise would have, prompted a jury pool to be jaded in some way? And again, Dana, you've identified in so many ways what is animating all of these attempts by the judges to shut down these kinds of inappropriate comments inside and outside the courtroom related to the legitimacy of those proceedings. And I have always said, and I think what you're going to see coming out of the Court of Appeals in District of Columbia, certainly coming out of the appeals court in the state of New York just this past week, that yes, indeed, someone like Donald Trump does have First Amendment rights. Every defendant, state or federal system, also has a First Amendment right to speak. What do you have a right to speak about when it comes to the prosecution, a criminal prosecution? I would add even a civil piece of legislation. You can say general things like, I am not liable. I am not guilty. I am not the one who did the things that are alleged in the indictment. You can even go further and ascribe some bad motive, if you want, to the prosecution itself, civil or criminal. When I was U.S. attorney, it wasn't unusual for, it was atypical, but sometimes happened that you got criticism for the very bringing of the lawsuit, and that comes with the job. What is not appropriate is commenting on the specific witnesses and commenting about their legitimacy, their credibility, the kinds of things that could in fact implicate, again, what they're going to say during the course of the trial, could have a chilling effect. We've seen that with Donald Trump before, when he not only dangles pardons in front of some people when he is president, but also suggests outright that they should testify in certain ways. That's called witness tampering. And to answer your question in part, Dana, if in fact, and these are difficult cases to prove, if in fact you can draw that direct line between things that are said, regardless of the outcome of the trial, and a witness comes forward and says, I have been intimidated, I have been threatened, which regrettably would be the most compelling case of all. I've been threatened by this defendant. That in itself, that's obstruction of justice. That could be the source of a separate criminal prosecution. Not easy to show, right? Especially when you've got statements of the kind that Donald Trump is making. It is much more difficult, of course, to show that these kinds of things affect the jury pool, the people called in, what's called the veneer generally, from whom a jury is selected. Much more difficult to show that somehow you've infected that process. But that's the reason why these judges, these justices, are looking at all this and saying that as they attempt to both balance the interests of the defendant, Donald Trump, and being able to speak about on the campaign trail in other settings about what he thinks is the unfair prosecution against the legitimacy of the trial proceeding itself. When you balance those things, there's a line that can be drawn, and it can be drawn very clearly. And as Justice or Judge Engeron says, those things can be enforced. And some of the remedies include, of course, depending upon whether there's civil or criminal contempt, they can include fines. They can include the imprisonment if, in fact, you've committed that contempt in the presence of the court. Could be a separate proceeding. All sorts of procedures go along with these kinds of things. But there are remedies. There are remedies both internal to the proceedings as they're being conducted and also after them. It's not easy. It's not easy. But in fact, there are things that can be done. The point right now is these judges doing all kinds of things to ensure that the trials as they go ahead do not bring into the courtroom the effects of these statements, that the witnesses are not intimidated, that you do not have threats that are visited upon them, that the juries, when they do come in, can in fact set aside whatever views they have and make determinations based upon what they see in the four corners of the courtroom. Those are the questions to be asked of these jurors in these criminal and indeed civil cases as they go forward in the times ahead. Great question. Remedies, not always easy. not always accessible immediately, but available out there depending upon what happens here. Final comment about your very good comment, Dana, and that is that, yes, indeed, to the extent that Donald Trump maintains that he is being treated unfairly, indeed, just the opposite. You commented along the way that he's been given an awful lot of leeway. Indeed, he has. I will tell you from my own experience, 30 years as a criminal prosecutor, civil litigator as well, in the federal, civil, and criminal courts, if defendants, and specifically if other attorneys, if any parties, even witnesses engaged in this kind of behavior, they would be before the court and there would be sanctions imposed. These judges are plainly giving him a very, very broad scope of activity in which to engage because they recognize that he is indeed a candidate. Whether that should be a consideration is one of those things that reasonable people can differ on. Judge Chutkan, other judges have said that you have no greater or lesser status than any other defendant. And if that is the case, if that is the truth, then when it comes to violating these so-called gag orders, these restrictive orders, they should be subject to the same kinds of penalties that any other defendant would be facing in the federal district courts here in Wisconsin, the state courts here in Wisconsin, and throughout the United States of America. Many, many important things out there to chat about. We'll continue to be on top of all those things. Lots of things coming up in 2024, including, once again, according to Judge Chutkan, as late as this past week, the initiation, the start of that criminal trial in her courtroom. Other cases in New York, other cases in Georgia. Also, just this past week, the subject of some hearings in front of Judge Scott McAfee, who's the state court judge there in Georgia, presiding over that omnibus, many, many pages of indictments, 19 defendants, 15 still viable defendants, and wrestling with this question of when this case goes to trial. Lots of interesting discussion coming out of that hearing just this past week. Not a clear trial date set yet for Georgia, but probably that one among all the trials going ahead, probably the last of them. More generally, certainly predicting that 2024, when it comes to not only the campaign for the presidency, but also all of these trials, 4 different criminal trials, other civil trials. E. Jean Carroll has a civil trial, the second portion of her defamation sexual assault trial. That's beginning in January as well. Many other cases around the country going to trial when? Right in the midst of our presidential campaign, right at the time of Super Tuesday, during the course of conventions that are going to be taking place here in the state of Wisconsin, in Milwaukee, the Republicans coming here in July, the Democrats in Chicago, all of that contemporaneous with the administration, the oversight of the rule of law in our courts in 2024. We'll stay on top of all of that. When we come back, we're going to go back to the United States Supreme Court in memory and in hallowed memory of Sandra Day O'Connor. We will talk more about cases pending before the High Court in our final segments here on our Saturday morning broadcast. We are back here on our Saturday morning broadcast. Thank you for joining me. Thank you for joining my wonderful producer, Greg. Together, we're presenting this program to you about law, justice, and the aspiration for justice in America. Focusing a lot on government, a lot of courts this week, as we always do. And in that connection, let's return to things before the United States Supreme Court, not only in reverent memory of Sandra Day O'Connor, but also understanding the legacy and the possibility, what has happened historically to that legacy over time when new justices take the place of justices of the past, and the importance of understanding the through lines, if you will, of history when it comes to judicial doctrines. In the past, we have talked a lot about some of the major cases pending before the Supreme Court, and this morning is no exception. We're going to do a couple of different things. We're going to be talking about what's been on the docket, what is going to be on the docket of the Supreme Court just this coming week. So you can tune in for those live arguments. You can go back online, pull up the actual oral arguments of the justices with the lawyers who are appearing in front of them. I'll tell you more about the cases coming up just this past week. And I'm going to spend some time talking and focusing in particular upon a major oral argument that they had. The Supreme Court justices entertained just this past Wednesday, the 29th, in a case called SEC versus Jarchese, going to whether or not the Securities and Exchange Commission itself is constitutional. That may sound like a very academic issue, and in some ways it is. But in other ways, in combination with two other cases also pending before the Supreme Court, is a part of a focus of this Supreme Court on our administrative agencies, their legitimacy writ large, whether or not the system of government that calls upon experts inside our administrative agencies to make judgment calls and to make decisions about things that they know about, whether that entire system should be thrown back, should be withdrawn. And in particular, where the thing called the Chevron doctrine that permits and actually even directs that courts defer to the wisdom of scientists and mathematicians and medical people and educators and bankers and financial people and sometimes even lawyers, certainly everybody, artists in our community. That deference should no longer be out there as a part of our system. In the present campaign, an awful lot of talk about something called the administrative state and this notion that somehow the administrative state, which actually keeps our government functioning and keeps us not only responsive to the world in which we live, but keeps our government responsive to that, whether that should all be withdrawn. An awful lot of attack, if you will, upon the way in which government works today, and some of that seen just this past Wednesday in an oral argument in this SEC versus Jarchese case, about which we will talk in just a few moments. Let me tell you a little bit about where the Supreme Court is today. Every single year, every single term. This is the 2023-2024 term, begun in early October, finishing on September 30th of next year, but probably all of these major decisions being issued in May, maybe June of the coming year. All of those numbering somewhere around 60, maybe 70 cases in recent years. Just this past term, just about 60 cases. Right now, as of this morning, the Supreme Court has granted cert, or certiorari, which is his Latin phrase, the writ, basically commanding a lower court to send up the materials. It's their decision to review a lower court decision. The writs of certiorari having been granted in 46 cases, jumped a little bit just this past week from 44 just this past year, and probably another 15, maybe 20 more cases going to be on the docket before the Supreme Court is done addressing all the cases that it will address in this term. And sure enough, among those additional cases that it placed on its docket for review this coming term, finally is one from our own circuit, the United States Court of Appeals from the Seventh Circuit. Up to now, no cases coming up from the Seventh Circuit. That changed this past week in a case called Erlinger, Erlinger versus the United States. For the first time, the Supreme Court taking up a case under something called the Armed Career Criminal Act. I spent a lot of time as a prosecutor applying, talking with both defense counsel and certainly investigators, agents, and especially judges about the implications of the Armed Career Criminal Act. And the question in particular here, which we'll talk about down the road, this Seventh Circuit case now before the Supreme Court, is whether the Constitution requires a jury trial and proof beyond a reasonable doubt to find that a defendant's prior convictions, the prior convictions of a defendant, were committed on occasions different from one another. In other words, different discrete events. What does the law say about that? And if there's an enhanced penalty imposed under the Armed Career Criminal Act, does a jury have to decide that? What about that issue? That's pending before the Supreme Court now, coming out of our own Seventh Circuit for decision, probably again in May, June, maybe even July of next year. A couple of other things you can anticipate coming up in this coming week. Mark your calendars. Those of you who are not only available while the oral arguments are going on live, those of you who, when you come back from work, come back from your events with your family, other activities of your lives, can also pull these up on the Supreme Court website as well. 3 different cases coming up for oral argument this coming week, the 4th, the 5th, and the 6th. Let me tell you just a little bit about them because it underscores, again, the significance of all these kinds of things the Supreme Court is addressing that do affect our lives. Not going to spend a lot of time discussing the merits of those this morning, but simply to alert you that on the 4th, that is Monday, coming up in just a couple of days, the Supreme Court hearing a case, oral argument called Harrington versus Purdue Pharma. And yes, indeed, this is the opioid epidemic case having to do with the Sackler family and opioids coming out of that operation. You know it well. The question here is just this. Chapter 11, which is the organization proceedings in a bankruptcy court, a federal appellate court in reviewing a decision by a bankruptcy court to reorganize Purdue Pharma in the wake of this opioid crisis and the catastrophic impact that the Sackler family had in placing these opioids in our national population. Seeking reorganization, the bankruptcy court reorganized Purdue Pharma in such a way that not only did it reconstitute the organization, but also significantly protected the debtor here, which is Purdue Pharma, from claims brought by people who are still seeking remedies for that opioid distribution. The question is, does a bankruptcy court have the authority to approve a business reorganization plan for a company that shields that company from lawsuits for its role in the opioid epidemic? Fascinating case, important case having to do with Purdue Pharma, the Sackler family, and the opioid epidemic that, as we know, continues to ravage our nation. That's on Monday. On Tuesday of this coming week, a case called Moore versus United States, perhaps a little bit less interesting topically, but still very important. Case called Moore versus United States. The case concerns the 16th Amendment to the Constitution and Congress's authority to tax sums of money without apportionment among the states. Where the 16th Amendment authorizes Congress to tax what are called unrealized sums of money without apportionment among the states. That's coming up on Tuesday. That's Moore versus United States. And then on Wednesday, and this will be the last oral argument before the holidays, before the Supreme Court takes a brief break until coming back in mid-January. But on Wednesday, December 6th, another fascinating case that, again, not a criminal case, but a fascinating case having to do with employment discrimination. This one's called Muldrow versus City of St. Louis. It's being argued on December 6th, which again, this coming Wednesday. The question there is, does Title VII of the Civil Rights Act, which is this omnibus statute that prohibits employment discrimination based upon immutable characteristics. You can't discriminate America, again, not only under the Constitution, equal protection, due process, all of those kinds of fundamental notions, but codified then by our Congress in Title VII that says you cannot discrimination, hiring, firing, terms and conditions of employment based upon immutable characteristics, including sex, including race, national origin, ability, disability, orientation, gender identity, familial status, all kinds of immutable characteristics out there. The question is, does Title VII prohibit discrimination claims going forward as to all terms and conditions of employment, or only those that cause demonstrable, clear, credible, material disadvantages for the employees who are seeking redress? How does this come about? Well, it turns out that in a claim of gender discrimination by a female police officer, an assignment of her, she's transferred between law enforcement units. And that transfer is one to which she objects, not because it results in a reduction in her wages, not because it results in any purely adverse consequences, but rather it is a change that she does not prefer. The question is, without that demonstrable material disadvantage for her and those kinds of very credible things, do the other damages that she maintains apply to her that were visited upon her? Is that the kind of thing that Title VII also prohibits? An interesting question about the breadth, the scope of Title VII, again, having to do with a law enforcement officer, but plainly applicable across the board depending upon what the Supreme Court does, again, probably May or June, in Muldrow versus City of St. Louis being argued this coming Wednesday. 3 cases coming up for determination very, very soon and in the term of this Supreme Court. I indicated last week that just this past week, we did have other cases argued before the Supreme Court. One of those called Brown versus U.S., Jackson versus U.S., again, having to do with the Armed Career Criminal Act. That was on Monday. Again, what a serious drug offense is all about. On Tuesday, we had a case called McElrath versus Georgia, a fascinating double jeopardy case that focuses on whether or not a second prosecution, a criminal prosecution, can happen in the state of Georgia after a jury there returns what everybody acknowledges is an inconsistent verdict. On the one hand, finding the defendant not guilty by reason of insanity. In another case, finding him guilty by reason of having committed the event in a sane condition. It's called an irreconcilable verdict. And the case coming up from the Georgia Supreme Court, whether or not double jeopardy prevents the state of Georgia from prosecuting the defendant a second time for that case, for that prosecution unit for which he was acquitted. Or does the entire verdict get thrown out and the prosecutors get to start over all over again? That case was argued on Tuesday, McElrath versus Georgia, also along with a second case coming out, not of Georgia, but of the Third Circuit, called Wilkinson versus Garland. An agency determination, again, this gets us into the big case from just this past week, an agency determination that a given set of facts rises to the level of exceptional and extremely unusual hardship. Whether that's a mixed question of law and fact, how do you determine that? What about discretionary judgments? Again, looking at what agencies do in determining mixed issues of law and fact and hardship, in that case called Wilkinson versus Garland, all sounding very academic, but important, as is this major case that was also argued on Wednesday, the 29th, SEC versus Jarchese. Let's talk about that right now, because once again, it falls among the category of 3 different cases before the Supreme Court in this term, in which the Supreme Court is addressing this larger issue of the legitimacy of the administrative state, those words in quotes, the administrative actions of our many agencies in the federal government. We know from our previous discussions that the Supreme Court, on its very first day, entertained oral argument involving the legitimacy of the Consumer Financial Protection Bureau, this agency identified and organized by Congress to protect small lenders, small debtors, if you will, getting loans from lenders. And along the way, a challenge to the CFPB on the basis that it doesn't get funding directly from the Congress, but in fact gets funding through the Federal Reserve, whether that funding line, not through the Congress, not through the appropriations process under the Constitution, but rather through fees and other assessments made by the Federal Reserve, an indirect funding source, renders the CFPB unconstitutional and should be shut down in place ever since 2008. Supreme Court at that time, early part of its term in October, probably disinclined to agree with the petitioners who say that the CFPB should be shut down. But nonetheless, it's out there. The larger issue that's going to be coming up again in mid-January when the Congress comes back, when the Congress and the Supreme Court come back, all of them on Capitol Hill, January 17th. The Supreme Court is going to be issuing or entertaining oral argument in a case that we're going to talk about right after this break here on our morning broadcast. And we are back for this, our final segment here in our Saturday morning broadcast. Thank you for joining my terrific producer, Greg, and me for our discussion this morning. As always, appreciate not only your attention, your focus, your listening focus on our discussion, but as is the case every Saturday morning, your questions and your comments. A brief programming note also as we go into this, our final minutes. Next Saturday, December 9th, our 75th broadcast here on the radio broadcast stations of Civic Media, a special focus on what I'm calling the future of America, focusing on promises made by a presidential campaign right now about what happens if indeed this particular campaign is successful in retaking the White House. We're going to spend a lot of time talking about the rule of law implications when it comes to a lot of the discussion in our public domain right now in the campaign process. What if these things that campaign advocates for the presidency, what if they come true? And talking about the future of America, talking about the future of America next Saturday in a major, significant, spending a lot of time contributing to the public discussion about not only the campaign, but also that viewed through a rule of law, a justice, a government lens, if you will. What can and can you not do as a president of the United States of America? We know that the Supreme Court, again, is going to be entertaining similarly important questions coming up in January. I mentioned right before the break that on January 17th, it is going to be entertaining oral argument in a major case called Loper Bright Enterprises versus Raimondo. And the question there, a huge question, one of the major cases pending before the Supreme Court, arguably the most important of all, should a long-standing principle of judicial deference to the experts who reside and interpret the law inside our federal agencies in situations when the law is not clear, should that deference be abandoned? It's called Chevron deference, and it comes up in a case called Loper Bright Enterprises versus Raimondo, another related case. We're going to talk more about that in January. But it brings us finally to our discussion of this major oral argument of just this past Wednesday in SEC versus Jarchese. And this case, again, falls among the category of these three cases that address whether or not our administrative agencies are legitimate. Mr. Jarchese himself finding himself on the receiving end of some significant penalties, about $300,000 or so, for his mismanagement of some $24 million in hedge funds. And the SEC launched an administrative investigation of him. And the agency fined Mr. Jarchese, again, $300,000, barred him from participation in the securities industry, ordered him to give up nearly $685,000 in unlawful gains. That's what they did as a result of the administrative function of the SEC. Now, Mr. Jarchese, not happy with that result, not only came back and said no basis for the SEC, these administrators, these security folks inside the SEC to do this, but also attacking the SEC itself and saying that for the past 90 years, almost an entire century, the SEC itself has been operating unconstitutionally. And in particular, he has said a number of things. That way back in 1933, 1934, when the SEC was first constituted, Congress failed to give it clear marching orders with respect to what it's supposed to do. Now, they did commission it legislatively, but plainly could not envision what would happen over the period of years, 100 years of administrative oversight. He says that the Congress failed to give them the significant amount of direction, and for that reason, the agency has unconstitutionally been operating for the last 9 decades. He also says that this particular agency is not sufficiently tethered to another issue, which we're going to talk about next Saturday when it comes to the presidency and the role of the presidency when it comes to our administrative agencies, this administrative state concept. He says because the SEC is not sufficiently tethered to the White House, to the executive branch, likewise, for that reason, it is unconstitutional. But most significant, and the thing that the Supreme Court focused on principally just this past week, was this claim that under the 7th Amendment to the Constitution, Mr. Jarchese and everybody who appears in front of the SEC is entitled to a jury trial for the kinds of things that the SEC was imposing upon him. Never done in 90 years, and prompting Elena Kagan, among others, to say, you must be joking. You're coming now and you're alleging that the SEC is unconstitutional because it has not granted you this right that has not been acknowledged by the Supreme Court in the past, not a part of the legislature for 90 years. And the attorney for Mr. Jarchese says, yes, it hasn't been thought of before. And Elena Kagan comes back in one of the most notable exchanges of the oral argument. She says, that's chutzpah. That's chutzpah to come before this court and to maintain that. However, Elena Kagan plainly not in the majority of the Supreme Court justices entertaining oral argument on the Jarchese case just this past week. A majority of the court seeming, again, reading the tea leaves, we don't know for sure, but seeming to suggest that indeed Mr. Marchese and others do in fact have a Seventh Amendment right to a jury trial for all of the administrative decisions made by SEC officials as a part of their administrative function commissioned by the Congress for the past 100 years or so. Many members of the Supreme Court quizzing both the government, or the Solicitor General, and also Mr. Jarchese's attorneys on why it is that something of this significance, a decision by an agency to impose these fines, to fine him, to bar him from future securities engagements, should not be subject to a Seventh Amendment jury trial. Again, if they go down that road and find that indeed the SEC needs to afford individuals this kind of due process at that level, a huge change, a huge attack, if you will, an amendment to the way that the SEC does its work on a regular basis has implications of a huge collateral nature, not just upon the SEC, but upon many other agencies. And that's why this case is so incredibly important. The SEC looking to it, going to be looking very closely at what the Supreme Court says about this jury trial issue in May or June. But beyond that, we all look in connection with the Jarchese matter, in connection with the CFPB case, and indeed in connection with the Raimondo case having to do with whether or not judicial deference should be supported. All of that, plainly a focus of this United States Supreme Court in this term. When we come back again next Saturday, a great deal of focus upon the interplay between agencies and upon the executive branch talking about promises made by candidates in the presidential campaign. Join us next Saturday again here on our morning broadcast for that discussion. In the meantime, have a good week, everybody.